In this video, I'll review the foundational key legislation that impacts employment. These 4 acts shown in the boxes are listed from earliest to most recent. They'll be covered in summary format, indicating who they apply to, the provisions, and the compliance requirements. The website where the full act can be found is provided. The National Labor Relations Act, NLRA, of 1935, or the Wagner Act, was passed as part of the President Franklin Roosevelt's New Deal and is touted as the granddaddy of all labor relations laws in the United States. At the time, it was referred to as the Labor's Bill of Rights and represented a landmark change in the government's attitude towards unions. The act allowed for employees to organize, bargain collectively, and engage in concerted activities for the purpose of collective bargaining or other mutual aid or protection. The right to engage in concerted activities applies not only to union employees, but to non-union employees as well. The act went on to identify 5 unfair employer labor practices and created the National Labor Relations Board, NLRB, to enforce provisions on the act. The NLRB is also charged with conducting elections and preventing and remedying unfair labor practices. The NLRB doesn't investigate actions on its own. It responds to charges on unfair labor practices or petitions for representation elections filed in one of its offices. The National Labor Relations Act, NLRA, is sometimes called the Wagner Act, after its writer, Democratic Senator Robert F. Wagner. Some key provisions are mapped to the 4 sections shown in the table. Section 7 Rights. This applies to all employees, and it gives them the right to organize, join unions, and engage in the collective bargaining and other concerted activities when they meet the protection standards. Social media posting is just one of the things employers may not realize are covered by the Act. Many companies have rules that ban employees from discussing their salaries, and the NLRB has held that employees have a right to discuss their pay and work conditions, so enforcing a no discussion policy could violate Section 7. Likewise, forbidding employees from discussing disciplinary actions the company takes against them could be a breach of their Section 7 rights. Section 8. It prohibits employers and unions from interfering with, restraining, or coercing employees in exercising their Section 7 rights. Section 8A2. Prior to the passage of the Wagner Act, many companies established company unions for the benefit and support of their employees. These company unions, however, were run by management and did not serve as an effective bargaining representation for the employees. To eliminate the situation, the Wagner Act declared that company-dominated unions were illegal. Section 9. This governs the election process, including bargaining topics, determination of bargaining units, and the NLRB's petition and hearings, and the election process. The Fair Labor Standards Act, FLSA, of 1938 is commonly referred to as the Wage and Hour Law and establishes the foundation for employee treatment. It is a major influence in how individuals are paid, the employment of young workers, and how employment records are to be kept on issues of work hours. The law introduces a maximum 44-hour, 7-day work week and establishes a national minimum wage guaranteed time and a half for overtime in certain jobs, and it prohibits employment of minors in oppressive child labor, a term that is defined in the statute. It applies to all employees engaged in interstate commerce or employed by businesses engaged in commerce or in the production of goods and commerce, unless the employer can claim an exemption from the coverage. This act was the first federal law to require employers to maintain records on employee race and sex identification. This is an extensive law and should be reviewed and understood by HR professionals. When hiring a workforce, it's important for business owners to understand the various options of workers and the tax implications. Two major categories are independent contractors who bill for their work and receive 1099 tax statements, and employees who are paid on the payroll and receive W-2 tax statements. An employee is a worker hired by a company to perform specific duties in exchange for payment, typically in the form of hourly or monthly wages. They can be further categorized as exempt and non-exempt from FLSA regulations under DOL. Independent contractors can be an individual or company providing labor to the business under terms specified in a contract. They generally have control over their schedule and are expected to work as needed. Independent contractors are not covered by FLSA. The Fair Labor Standards Act, FLSA, covers all employees except those identified in the law as exempt from the regulations. The termination of exempt status is often misunderstood by both employers and employees. Employers often think that they will save money by designating jobs as exempt and paying employees a salary. Employees often see the designation of a job as exempt as a measure of status within the company. Neither of these perceptions are accurate, and jobs that do not meet the legal exemption requirements can have costly consequences for employers. To assist employers in properly classifying positions, the DOL regulations include exemption status tests, which is depicted in the process flow shown to determine whether a job meets the requirements and is therefore exempt from FSLA regulations. If the box can be answered yes, the employee is exempt and not covered by FLSA. If the box can be answered no, the employee is considered non-exempt and will be covered by FLSA. The non-exempt employees must be paid in accordance with FLSA requirements. Certain positions may be exempt from one or all of the FLSA requirements, minimum wage, overtime, or child labor. For example, police officers and firefighters employed by small departments of fewer than 5 employees are exempt from overtime requirements, but not exempt from the minimum wage requirement. On the other hand, newspaper delivery jobs are exempt from the minimum wage, overtime, and child labor requirements. FLSA requires the maintenance of accurate records by all employers. The information that must be maintained includes personal and biographical information, employment, which is assignment data, labor details. In general, the positive time method is the best for non-exempt employees because it leaves no doubt as to the actual hours worked by the employee and protects both the employee and the employer if there's ever a question about overtime payments due. DOL regulations will also accept exception reporting, which is typically used for exempt employees. And then payment details. FLSA requires employers to keep records of wages, hours, and other related items. These records are usually maintained by the payroll department and must be preserved for at least 3 years. Overtime is required at the rate of 1.5 times the normal rate of pay for all hours worked over 40 hours in a single work week. Regular rate of pay includes all performance-related compensation such as bonuses and commissions. Hours worked includes all the hours the employer suffered the employee. An employer may designate that their work week begins on a given day and hour and continues that same day and hour 7 days later. Once selected, that same work week definition must be maintained consistently until there's a legitimate business reason for making a change. A change must be clearly communicated in advance to all employees who will be affected by the change. An employee should not forfeit pay because the employer changes its workweek definition. Compensating time is permitted under FLSA if it is given at the same rates required for overtime pay. The federal child labor provisions of the FLSA, also known as the child labor laws, were enacted to ensure that when young people work, the work is safe and does not jeopardize their health well-being, or educational opportunities. These provisions also provide limited exceptions, which are outlined in the table by age group. Children of any age may work for a business owned entirely by their parents unless they would be employed in mining, manufacturing, or other hazardous occupations. Children 16 years of age and up may work for an unlimited number of hours. Children 14 and 15 years of age are restricted to jobs such as newspaper delivery to local customers, babysitting on a casual basis, acting in movies, TV, radio, or theater, working as a home worker, gathering evergreens and making evergreen wreaths. Under no circumstances, even if the business is family-owned, may a person this young work in hazardous jobs. The work hours must be outside of school hours and have restrictions. There are no restrictions for a youth 18 years of age or older. The Portal to Pay Act of 1947 amended the Fair Labor Standards Act to define hours worked and clarified what was considered to be compensable work time and established that employers are not required to pay for employees to commute. One exception to this general rule is when an employee's workday has ended and they are called back to work and have to travel an unusually long distance to get to a work site after normal working hours. That travel time may be counted as hours worked. The Act requires employers to pay non-exempt employees who perform regular work duties before or after regular hours or for working during their lunch period. The Act and its regulations provide some helpful guidance regarding when an employer must count travel time as hours worked for wage payment and overtime purposes. Employers, especially those whose employees are frequently on the move, are wise to understand the obligations to employees who travel. Under the Portal to Pay Act, employers do not have to pay a non-exempt employee for hours spent when traveling when those hours occur outside of the employee's normal work days and normal work hours, and the employee does not work during those hours. Unless both of these conditions are met, the employee must be paid for those hours. In the example shown, the non-exempt employee's normal work hours are 9 a.m. to 5 p.m. Monday through Friday, and the employee is going on a weekend work trip. On Friday, the employee would be paid 5 hours because the trip commenced during the normal workday and work hours, and payment must be until conclusion. On Saturday, the employee is paid for 12 hours because the employee worked the entire day. On Sunday, the employee is traveling back, leaving at 7 a.m., but the hours start calculating during what would have been the regular work hours until the trip concludes for 4 hours of the 6 hours of travel time. However, if the employee was driving, the entire time would be paid for 6 hours of paid time. The Immigration and Nationality Act INA of 1952 is the first law that pulled together all the issues associated with immigration and is considered the foundation on which all following immigration laws have been built. It addresses employment eligibility and employment verification and defines the conditions for the temporary and permanent employment of aliens in the United States. The Act defines an alien as a person lacking citizenship or status as a national of the United States and differentiates with 3 categories: resident or non-resident, immigrant or non-immigrant, documented and undocumented. The need to curtail illegal immigration led to the enactment of the Immigration Reform and Control Act, HRCA.